Yeah, sorry to go to reading. Yes, Mr. Scott.
Well, as your lordships know, we say the judge was right to dismiss Xiaomi's interim application for declarations for the reasons set out in his judgment. The judge reached two core conclusions. First, there was no legal basis for the declarations sought because Xiaomi could not establish the factual allegation of bad faith upon which its case for those declarations depended. Second, it would in any way, concluded the judge, be wrong in principle to grant those declarations, since on the facts of this case, they serve no useful purpose, being sought solely and illegitimately to influence the outcome in Germany. To sustain its appeal, Xiaomi would have to persuade you lordships that the judge was wrong so to conclude on each of those core points. We say he was wrong on neither. My lords, I want to develop that submission in three parts. First, some overarching points about the landscape of the dispute between Panasonic and Xiaomi, the commercial and legal context in which we are pursuing parallel proceedings, the considerations of territoriality and comity that come into play here, and the position of the German courts and the UPC in all of this, and what those courts are actually going to do, which is, as we shall see, very different from the description that Mr. Alexander provided this morning. That will be the first topic. The second will be to address Xiaomi's contention that the judge erred in concluding that there was no legal basis for the declarations. That is grounds 1, 2, and 5 of the appeal. And the third topic will be Xiaomi's contention that the judge erred as regards his conclusions on useful purpose and comity. That is grounds 3 and 4. But, my lords, before I get into those three main topics, can I deal briefly with a number of the points that arose in argument this morning and give you lordships our answer to them, which I will develop in the course of my submissions. Now, the first of those points was my Lord Justice Phillips' question, why no application for an anti-suit injunction? Now, obviously, there is no application for an anti-suit injunction. Never has been, nor is there one now. Our position is that there would be absolutely no basis for an anti-suit injunction. Now, we say that in particular because the starting point in this entire debate is that we are not in breach of our undertakings to the English court. There is no allegation from Xiaomi, well, there was no allegation from Xiaomi below that we were in breach of those undertakings. And there would be no basis for such an allegation. If I can invite your lordships, please, to the learned judge's judgment, at page 138 in the core bundle behind tab 8. And just to give you lordships where we are in the judgment here, the judge is addressing here the objective question of bad faith and giving his reasons why there was none in the present case. Your lordships see at the top of page 138, the judge's first reason is that my learned friend's predecessor, Mr. Bolton, did not suggest that Panasonic was acting in breach of the Panasonic undertakings by continuing to prosecute the German proceedings in both the UPC and the German courts. Indeed, they were careful not to do so, and in my judgment, rightly so. Panasonic gave those undertakings to the court, not to Xiaomi, to fulfill its FRAND commitment. Moreover, Panasonic's counsel made it quite clear to me, Jay, that it was reserving its rights to prosecute the German proceedings, notwithstanding the reciprocal undertakings. The judge may have found this position unattractive, but neither the court nor Xiaomi could have been in any doubt what Panasonic's intentions were. And indeed, having regard to the terms of the undertakings, which are set out in an earlier passage of the judgment, and the context in which they were given as recorded in the second subparagraph. Any case that our pursuit of the German proceedings and the UPC proceedings are in breach of those undertakings would be unsustainable. And that is no doubt why it was not the case put to the learned judge. But the case put to the learned judge was that we are in breach of our ETSI commitment, specifically clause 6.1 of the ETSI IPR policy, as read in accordance with the French law doctrine of good faith, which is where bad faith comes in, because unless Xiaomi could establish bad faith, its case on breach of the ETSI IPR policy did not get off the ground.
But that wouldn't necessarily be the basis for an anti-suit injunction, would it?
I'm so sorry, Mother, I missed that would not necessarily be the basis. No, I was simply dealing with the first potential basis, breach of the undertakings, and explaining why our position is that there would not be a breach of those undertakings. The next potential basis I was going to consider was potential breach of the ETSI IPR policy itself. Of course, that is the issue the judge dealt with on the application, and he found in our favour on it. Our pursuit of those foreign proceedings was not, in the judge's view, in breach of any express provision, any implied provision, or the French law doctrine of good faith. What then about the idea that these foreign proceedings are interfering with the English court's jurisdiction? Because of course that would be a recognised basis for granting an anti-suit injunction. Well, again, that case would not run on the facts of the present case. If I can ask your lordships to move through the judgment, please, to paragraph 111. This is on page 148. The judge is dealing here with the suggested utility of the declarations and giving his reasons as to why they served no useful purpose. And your lordship see, the judge's first reason is this: there is no need to clarify the parties' respective rights and obligations in this jurisdiction. And then this: or take steps to preserve the integrity of these proceedings ahead of the FRAND trial. Panasonic has entered into the reciprocal undertakings and agreed to be bound by the court-determined licence. It has not asked the Xiaomi defendants to pay licence fees now, nor threatened to apply for an injunction if they fail to do so. It has made clear that it will accept the retrospective licence and rely on any rights which it may have to claim interest. So the learned judge certainly didn't think declaratory relief was necessary to preserve the integrity of the English proceedings. All the more so would anti-suit injunctive relief not have been necessary to do so, because the English proceedings have full and proper integrity as matters stand. Unless these parties...
If they have full and proper integrity, you don't need any proceedings in foreign courts.
Well,
because what we have got, where we've got to with the English proceedings, is that by virtue of the reciprocal undertakings, it is a certainty that there will be a licence, there is certainty that it will be on FRAND terms, and there is certainty that it will be retrospective and you will get full payment. In those circumstances, what need have you of any proceedings in any other court whatsoever?
because we think we can do better, my lord.
We think you can do better, better than FRAND. So that's admission that what your clients are trying to do is better than FRAND.
No, it's not. It's nothing of the sort, my lord. If your lordship will let me finish. FRAND is, of course, a range. There are a range of terms which the court may, in due course, conclude to be FRAND. Our preference is, as it has always been, that the parties reach a consensual solution to this dispute. We consider that that is most likely to result by the pursuit of the proceedings that we have on foot. And it is certainly true that if we don't achieve a consensual solution, there will be a FRAND licence on terms declared by this court. But that does not preclude the possibility of the parties reaching agreement on FRAND terms ahead of that. That is what we hope the parties will do.
So you are attempting to coerce Xiaomi into agreeing something better than you would get out of the English court?
Not trying to coerce them to do so, my lord. Lord, exercising our
Because if you're not going to get
legitimate
anything
legal
any better than the English court will give you, it's purposeless.
rights. I didn't dispute my Lord's point about getting something better than the English court. What I did dispute was the point about coercion. Because pregnant in the point about coercion is the idea that it is illegitimate for us to be pursuing our patent rights in Germany and in the UPC. We do not accept.
But you're invoking the English court's jurisdiction to determine the terms of a FRAND license, which would govern your use of your patents globally, and would cover the present position as well as the future. It's not clear to me why it isn't vexatious and oppressive for you, whilst doing that, to go and seek injunctions to restrain the defendants from using the patented items in the meantime.
Well, let me answer this way. If we had granted them a license, then of course those foreign proceedings would be vexatious and oppressive. But as matters stand, they are unlicensed. They are on the market using our property without our license.
But you have the certainty that they will be licensed. It's not merely a possibility, it's a certainty.
That's true, my Lord. I don't dispute that.
And if one applies the equitable principle that that which should be done is treated as done, then they are licensed.
But the case has not been put on the basis of that equitable principle. There is no evidence that that principle exists in French law. And certainly one of the issues for the FRAND trial, as I understand it, will be, or at least may be.
There's no dispute that they're entitled to a licence. The only question is how much. And you have the certainty that that's going to be determined by the English court independently and impartially, and therefore they will retrospectively be licensed at what a court has independently and impartially decided is FRAND.
My Lord, I accept.
What possible objection could there be to any of that?
No objection to that, my Lord, but with respect, it begs the question, are we precluded, in the meantime, from pursuing a consensual FRAND solution?
Well, no, you're not. You're free to negotiate, but what you want is the coercive power of an injunction.
Yes, just in the same way that the implementer wishes to have the coercive power of remaining on the market without our license and without paying us.
But we know they'll pay in the end, because there will be a license.
My Lord, again, I can't dispute that.
And they're offering to pay.
They are, but they're not offering to pay our terms.
But I don't see how that helps you, because as far as this court is concerned in this jurisdiction, this court will determine what the right sum is. So you can't complain about that in this court.
Well, I certainly can't complain once the terms have been determined by this court.
But you know that they will be determined by this court, so how can you complain prospectively about it?
Well, I'm complaining about the position now, when the offer on the table from Xiaomi now to be licensed to use our property is an offer to pay what Xiaomi wants for that privilege.
But that's
not what we are.
No, but that's the interim license. We're now talking about anti-suit, as I understand it.
We are. I am trying to address my Lord's questions about anti-suit, but the interim license comes up in that connection, because what Xiaomi is seeking to do is proceed on the basis that it is licensed now when it is not, and that would be the effect of an anti-suit injunction, because it would be to prohibit the patentee from enforcing its ordinary property rights pending the grant of a license. So, my Lord, I am indeed dealing with anti-suit injunction, but the anti-suit injunction issue is not divorced from the question of an interim license. Because if the court were to grant an anti-suit injunction, the effect of that would be that Xiaomi is de facto licensed, because it would be free to continue using our patents in Germany. And we would be unable to
just the same position as you accepted at the start of the hearing before Mr. Justice Mead, that you wouldn't enforce any injunction.
Indeed, my Lord.
Stay the proceeding.
The position accepted on day one tentatively, and which, having reflected further, Panasonic was not prepared to accept. And it's important that your Lordships bear in mind the procedural context of that hearing, That was a hearing at which Mr. Justice Mead was being asked to decide whether and to what extent to expedite the FRAND trial in these proceedings. And that was the context in which the undertakings were being sought. Now, it is certainly true, Panasonic initially suggested that it might be prepared not to enforce any injunctions obtained in Germany, and thereby not have the case in England expedited quite so aggressively as Xiaomi had sought. On further reflection, Xiaomi was not prepared to grant those undertakings. Sorry, Panasonic was not prepared to give those undertakings and did not do so.
Just going back to anti-suit, I'm not sure we've got the cases, but my understanding of obviously you have the whole area of anti-suit injunctions based upon exclusive jurisdiction clauses, arbitration clauses, angelic grace, etc., etc. We're not dealing with that here. We'll be dealing with a line of cases dealing with vexatious or oppressive proceedings, which are primarily concerned with parallel proceedings being brought with a view to duplicative and potentially inconsistent litigation and decisions. Now, it seems to me that initially the answer to that may be, well, these are what you're litigating in Germany are the German patents, not the UK patents.
Indeed.
But as soon as you have asked for and undertaken to accept the English court determining the global license which would cover the present, then it seems to me you're absolutely within that territory, because you are then litigating in Germany the very same rights and seeking inconsistent relief there.
My Lord, can I deal with that question in three parts? The first is to express respectfully our agreement with your Lordship's observation that we are not in exclusive jurisdiction clause territory. We are also not in the territory of anti-suit injunctions to protect the English court's jurisdiction. That leaves the possibility of anti-suit injunctions on the basis of vexation and oppression. And I was coming on to deal with that. And happily the judge did cite in his judgment certainly the, if not one of, the leading authorities on that question, this court's judgment in Deutsche Bank and Highland Crusader. Now, I will show you, Lordships, the passages in a moment. But there's also another aspect to keep in mind here, which is the patents aspect. Because in the patents context, injunctions to restrain foreign proceedings to enforce foreign patents are very rare indeed. And there is not one, so far as we are aware, that has ever been granted in the FRAND context.
That's not right. There have been anti-suit injunctions in the FRAND context. Well, admittedly, in somewhat different circumstances, but they have been granted.
Perhaps if I can address those different circumstances, because they are addressed in the judgment. The cases at first instance in which the Patents Court, in FRAND cases, have granted anti-suit injunctions are cases in which those injunctions were necessary to protect the English court's jurisdiction. There were cases in which implementers were bringing foreign proceedings which in some way interfered with the English court's ability to try the FRAND issues with which it was seized. If your Lordship will bear with me one moment, let me provide the references in the learned judge's judgment. Perhaps we can look at them. We're in the core bundle. If I can ask your Lordship to look at page 120, please. Can I ask your Lordship, please, to reread paragraph 72 and then the quotation from Phillips and Oppo, which is one of a handful of cases in which anti-suit relief has been granted by the English court in a FRAND context.
what's missing from that, isn't it, is the fact that in this case both parties are undertaken to accept the outcome of the FRAND determination.
That is true, my lord. That was not a feature of the Phillips and Offa case, and it is a feature of our case. But we do say on analysis it makes no difference, because proceeding through the steps I have proceeded to, is there an English exclusive jurisdiction clause? No. Do the foreign proceedings threaten or prejudice the English court's jurisdiction? No. That brings one to vexatious and oppressive conduct. And your lordship has my submission that we are not engaged in that. My lord, on vexation and oppression, I said I would show you the passages from this court's decision in Deutsche Bank. They're set out by the judge from page 118 in his judgment, beginning at paragraph 70. Perhaps I can invite your lordships to reread paragraph 70 down to paragraph 71. And note in particular the importance that this court attached to comity and to not interfering in cases save where the foreign court is breaching customary international law. And also the need for the English court to be satisfied that it is the natural form.
So your case is that there is no, just in inverted commas, remedy available to deal with a situation, factual situation that's arisen in this case and in other similar cases.
Not at all, my lord. On the facts of this case, there are a series of remedies available. One is for Xiaomi to pursue the Orange Book procedure in Germany, whereby it would accept a license on our terms and then contest the terms before a court subsequently, which will rule on Xiaomi's arguments either way. Another remedy is to accept the non-enforcement proposal which we made before the judge below and still make now, whereby Xiaomi could be licensed now on our terms, subject to revision in due course by the English court following the FRAND. Another remedy, which Xiaomi has, is to make its arguments to the German courts, which it is doing as a matter of fact. And underlying really the entirety of the argument that Xiaomi makes is that instead of having to make arguments to the German court as to the reasons why injunctions should not be granted, it should make those arguments to the English court. The English court should grant declarations, and then those declarations should be taken to Germany to be relied on in front of the German court. And that, we respectfully suggest, is wrong. It's contrary to comity. The appropriate course is for Xiaomi to run its case in Germany, which is the only appropriate forum to decide whether or not injunctive relief should be granted.
So there's no remedy available which enables the court in this country to determine the terms of any license in the meantime. You say that's a matter that is not open to the court in this country. Because you've said the license now, but on terms as you've offered. So so that in essence it's within the control of the parties, not the control of the courts.
That's right, Moylan. It is within the control of the parties, and it is within Xiaomi's gift whether or not it chooses to take one or number of the remedies I've identified.
Even though
in fact, that's not a jurisdictional question, because you say there's no court anywhere in the world that can do that.
By that, does your lordship mean declare interim license terms?
It is implicit in your submission that no court anywhere in the world has the power to say what the interim terms for a license should be.
Well,
that's not a question between England and Germany or indeed anywhere else. It's implicit in what you're saying, no court anywhere can do it.
well, my lord, if I can deal with that this way, I don't put the point as a point about power. The English court obviously has a declaratory jurisdiction that is broad, and it can declare the parties' rights if those rights exist. But in exercising that power, the court has to proceed in accordance with principle. And one of the principles is the need for a useful purpose and not to make declarations solely to influence foreign courts. Now, if one applies those principles in the circumstances of this case, Xiaomi's application falls at every hurdle. There is no legal basis for an interim license in this case. And even if that were otherwise, it would be wrong in principle to grant the declarations in this case because it would serve no legitimate useful purpose. Now, there could be other cases...
When you say no legal basis, there is jurisdiction, but no
right.
reason to the circumstances would not justify the court exercising that jurisdiction. When you say no legal basis.
Yes, there is no underlying legal right.
Right.
The case for the declaration is put on the basis of an alleged legal right under French law, premised on showing that we are acting in bad faith. And the judge rejected that case. And the corollary is that the alleged legal right does not exist. And I readily accept there may be cases in which an implementer is able to show on the facts that the patentee is acting in bad faith. That would give rise to a legal right to support declarations. And there may be cases in which those declarations would serve a useful purpose in England. But this is not one of them. The only utility that these declarations could serve is in the context of the German proceedings, and that is illegitimate.
Can I just take you back to anti-suit for a moment? Sorry, I'm focusing a little bit more on that at the moment. But if the parties had agreed between themselves to refer the terms of their FRAND license to be determined by an arbitrator, that would undoubtedly, seems to me, give grounds for an anti-suit injunction if they then sought to go and litigate over the rights which were to be arbitrated in a different forum. I find it very difficult to see why it's any different. Why it's different when the parties have effectively agreed by virtue of their undertakings that license will be determined by the English court.
I certainly agree with your lordship about arbitration. The reason why in the context of arbitration agreements anti-suit injunctions readily follow is that arbitration agreements are construed to contain a negative promise not to bring the dispute otherwise than in arbitration, just in the same way that exclusive jurisdiction clauses are so construed. But that is not what these reciprocal undertakings are. They're not even an agreement between the parties. They're an undertaking from each side to do something in the future. And an undertaking given in my client's case, in circumstances where we made expressly clear to the court that we would not be staying our hand in Germany or the UPC. Now, it may well be in other cases that faced with that situation, a patents court judge may say, well, I need more by way of undertakings from you. If you want to press on with your claim in this jurisdiction, I will require you to undertake to bring a halt to your proceedings elsewhere. And a patentee in that situation would have to decide what to do. Either it would give the undertaking, or it would not, and that would be the end of its English action. But no one asked Panasonic to give that undertaking, and it never did so. As I've said, it made clear that it would be continuing with the foreign proceedings. It has done exactly what it said it would do when it gave the undertakings. So there is, in my respectful submission, no relevant analogy to arbitration or English exclusive jurisdiction clause cases. Which is why the case would fall, were it an anti-suit injunction case, to be decided under principles on vexation and oppression. And it would fail, in my respectful submission, in the light of the principles this court stated in the Deutsche Bank case. And it would fail as much as anything because of the comity implications of what the English court would be doing. And can I just show you, Lordships, the judge's observation on that aspect? You, Lordships, can go please to page 149. And the judge is dealing here with his reasons for not accepting the utility of the declarations. Can I invite you, Lordships, to read, please, subparagraph 6. My Lords, we say that finding is correct, and we say it illustrates why, had this application been run as an anti-suit injunction application, it would have failed. The final point I want to make on anti-suit injunctions is this, which is to draw your Lordship's attention to the likely reaction of the German courts. Now, that is not as some sort of inter rorem threat, but it is because it is important for your Lordships to see how, in deciding the willingness issues with which it is seized, how the German court would regard Xiaomi's conduct if Xiaomi had applied for an anti-suit injunction. I ask your Lordships, please, to take up the supplementary bundle at tab 8. Can we go to page 103, please? And to give you Lordships your bearing, this is the second report of Panasonic's expert, Professor Meyer Beck, and he's commenting at paragraph 15 on a point which Xiaomi's expert, Professor An, had identified about how the German courts react to anti-suit injunctions. Can I ask you Lordships, please, to read paragraph 50?
Why does that matter?
Well, my lord, it matters for this reason. Your lordship's question was, why is there no application for an anti-suit injunction? And I answer that two ways. Firstly, because there would be no basis for one, applying English law principles to the facts of this case. And second, because part of the likely explanation for why Xiaomi does not bring such an application is a concern on Xiaomi's part as to the likely reaction of the German courts in the context of ongoing resolution there of issues about willingness. That's the reason why it matters. It goes to the explanation.
Are you saying that you would not comply with the anti-suit injunction?
No, of course I'm not saying that, my lord.
Well, why would the German courts have anything to do with it?
Well, the German court...
The anti-suit injunction would restrain you from making any further applications to the German court.
Well,
so why would it matter what the German court would think, unless you were going to breach the injunction?
well, my lord, let me deal with that question this way. The proposal that we made on day one, before Mr. Justice Mead, was to not enforce any injunction we obtained in the German proceedings. It was not to stay our hand in Germany altogether. If those were the terms of the anti-suit injunction that the English court applied, we would be free to continue with our proceedings in Germany. We would just not be able.
The anti-suit injunction would provide that pending the determination of the FRAND license in the courts of this country, you desist in making any applications in Germany, and might also provide that you discontinue any proceedings you have commenced.
My lord, if that were what the anti-suit injunction provided, we would have to comply with it.
That's what they normally provide.
Well, it depends on the circumstances. And in the circumstances of this case, given the background, we do suggest an injunction in those terms would be entirely unjustified. You've heard my submission.
Okay, I didn't understand this. You're starting a trial, a lengthy trial in this court in October to determine the FRAND license. I'd have thought, applying the Deutsche Bank test, England is clearly the appropriate natural forum to determine the FRAND license, given that both sides have agreed with the English court that it should do so, would be bound by it. And justice would plainly require that the claimants in the foreign court should be restrained from proceeding there in the interim. Only between now and the determination of your claim in the English court. I disagree with you that the Deutsche Bank decision that wouldn't have scope for the grant of an anti-suit injunction in the interests of justice.
My lord, with respect, your lordship's observations are predicated on the assumption that we are asking the German court to deal with the same claim that we're asking the English court to deal with.
No, on the contrary, you're not asking them to do the same claim. You're asking them to grant an injunction which could put you in a better position than you're going to be as a result of this claim, when you've undertaken to this court to accept its decision.
And as I have said, and let me repeat the point so it's clear, we are fully committed to complying with our undertakings to the English court. If we proceed to the FRAND trial and a judgment is given, the parties do not settle their
dispute. No, but you want to put pressure on the defendant to your claim to agree to something different before that result, and you're doing that by commencing parallel proceedings in a different jurisdiction.
Indeed, and the question is whether or not that is vexatious and oppressive.
Yes.
And if it is, whether it would be consistent with comity for the English court to grant an anti-suit injunction.
Those are undoubtedly the questions.
Indeed. My submission is that the answer to each of them is a resounding no. But in some ways, the even shorter answer to them is that is not the application that I had to deal with below. It is not the application the judge had to deal with in his judgment. And it's not even the application that is being made now. The application that it was made to the judge is being made now is for declaratory relief, granted on an interim basis, without there having been any trial on the basis of allegations of bad faith under the Etsy policy. It may be that your lordships are against me on anti-suit injunction and consider that this case would have been a powerful one for an anti-suit injunction.
Well, for my part, it seems to me that if there isn't the possibility of an anti-suit injunction, that makes the case for an interim licence much stronger.
I see that, my lord, and I am not by any means saying that the court is powerless to grant an anti-suit injunction. Just on the fact of this case, we don't say that a case for such an injunction would have been made out. So there is no remedial gap, so to speak. The court has its usual powers to grant anti-suit injunctive relief. The court would just need to be satisfied that the case for that relief is made out. My lord, having said what we have to say on anti-suit injunctions, can I address now the second topic that arose in the course of argument this morning? And it was in the context of Mr. Alexander's submission to your lordship that the German court only considers whether the FRAND offer was devoid of all reasonableness, the obviously unfrand point. And that, with respect to him, is a fundamental mischaracterization of what the experts agreed would happen in the context of the German proceedings and what the judge found would happen. What Mr. Alexander's submission with respect does is to focus on the starting point of a multi-stage inquiry that the German court will follow. It is certainly true that at the start of the process, the German court asks whether the patentee's offer is obviously unfrand, its opening offer. But that is by no means the end of the German court's inquiry, because the German court takes account of all the parties' conduct up to the point in time at which it is asked to grant injunctive relief, including any further offers that have been made on either side, how each side has engaged with the other. Can I show your lordships a few passages on that aspect?
Can I just ask you a question about the German proceedings? The German proceedings are started in July 23, infringement claims seeking
injunctions restraining infringement and damages.
Right.
At least that relief. There may be additional ancillary relief, accounts and so on, but they are the two primary heads of relief.
And if I can put it positively, there's no prospect of those coming to determination prior to the determination of the proceedings in England.
My lord, can I take instructions on that point? Because I don't know on my feet the answer to when the final conclusion of those proceedings will be.
It depends what you mean by final conclusion. So there's a hearing, for example, on the 27th of September, which, at least in theory, could result in an injunction.
Well, my lord, I can say at least this. The hearing on the 27th will not result in an injunction because the German court has directed that it will not consider the FRAND issues at that hearing. That would be necessary in order to decide whether to grant an injunction. So I don't think 27th of September there is any risk whatsoever of an injunction being granted. What I can't answer at the moment is when the next date upon which the German court might grant an injunction would be. Can I return to my lord's question once those behind me have produced an answer to it?
Thank you.
I'm told there is a hearing in the UPC between the 7th and 10th of October, and it is possible, if the UPC is persuaded that injunctive relief may be granted on that occasion.
But not the damages?
No. And Ms. Jamal helpfully informs me that Xiaomi has applied to stay that proceeding, that hearing, as indeed it has applied to stay all of the proceedings in Germany pending determination in England. So those are matters that the German court will consider, along with indeed all the arguments that are being had about interim licenses, because each side is running in Germany.
It illustrates what a dysfunctional system it is, because we've got all this litigation going on in all these different courts, applications for stays in one court pending decisions in other courts. It's not a rational system, is it?
My lord, I readily recognise that were we sitting as legislators or drafters of the ETSI IPR policy?
Well, we
may
all know
wish
what
to
the
address-
answer is. It's a multinational, a global dispute resolution mechanism. We don't have that because it's not in the policy. But these parties are to be commended because both parties have recognised that what is needed is a court decision as to what is FRAND. And commendably, both parties have given undertakings to accept the court's decision. Wonderful. That's real progress. But then why disrupt it?
I've given the court the answer I gave to the judge, in which the judge accepted. Disrupt it, a pejorative term with respect, which we would see as exercising our legitimate bargaining power to achieve the best FRAND outcome that we can. And I recognise, of course, that if the German proceedings could properly be characterised as illegitimate, if, for example, the German courts were not going to take account of FRAND matters, they just handed out injunctions without looking at FRAND issues at all, it may well be that the court was satisfied that it would be illegitimate pressure to assert our German patent rights that way. That is a million miles from this case. We're dealing here with a sophisticated foreign court, applying an EU competition law framework that, as the judge observed, is not that dissimilar from the FRAND framework in this jurisdiction, in the context of which, as the judge found, there is no material risk of an injunction being granted in circumstances that would lead to super-FRAND rates. Those are the facts in which this case is in fact progressing, not the caricature that Mr. Alexander provided. We do say in that context, the judge was plainly right to conclude that it is not illegitimate for us to pursue our rights in Germany in parallel to our pursuit of rights in England. My lords, I was going to show you some passages on what is in fact happening in Germany. Can I make good that point? If we can go to the judgment, please, at paragraph 48. It's on page 105. Your Lordships should have at the top of that page the FRAND roadmap, as the party's experts termed it, derived from the CGE's decision in Huawei and ZTE as interpreted by the German court.
Sorry, which page again?
I'm on page 105.
105, sorry, thank you. Yes.
And what, in short, Mr. Alexander's submission did was to focus on step 3. The SEP holder must provide the alleged infringer with an offer in writing on FRAND terms. That's the step upon which the obviously unFRAND standard bites. With respect to him, his whole argument ignored the subsequent steps under which the German court will investigate how each of the parties is behaving in the context of the negotiations. And if I can then ask your Lordship to turn over to page 107. Your Lordships have there the judge quoting passages from Professor Meyer Beck's report. Can I ask your Lordships to reread that, please, noting that these are passages which the judge specifically accepted the later part of his judgment. We're at paragraph 52 of the judgment. Well, if I can then show you, Lordships, the judge's finding on this aspect. If we can go to page 138, please. Can I ask you, Lordships, to read these subparagraphs 4 and 5, and then 6 over the page?
Yes.
Where does the judge answer the question of what the point of the German proceedings is? Because if they result in the same FRAND rate being determined, it's pointless and awaits costs. So therefore, the only reason for pursuing can possibly be, as you've accepted, to get better terms.
The judge addresses it in answer to Lordship's question from paragraph 97 through to 100 of his judgment. And he's dealing there with Xiaomi's primary case below, that Panasonic was pursuing the German proceedings as part of a strategy, consciously to get supra-FRAND rates. And that is a case which the judge rejected on the facts, for the reasons he gives in these passages, in particular having accepted the unchallenged evidence of my solicitors given on instructions from Panasonic's chief IP counsel. Perhaps I should let you Lordships read those passages. It's 97 through to 100.
Doesn't seem to me to provide an answer to the question, but maybe I'm missing something. So what you Lordships have in those passages is the judge's reasons for rejecting the primary case below of subjective bad faith. And then what you Lordships have from paragraph 101 onwards is the alternative case that was put on bad faith viewed objectively. That is to say, whether the effect of Panasonic's actions would be, as the judge put it, to frustrate our FRAND commitment. And I've been showing you Lordships some of the reasons the judge gave for that, including his analysis of the German proceedings. Can I show you Lordships one last passage on the true nature of the German proceedings? Can we go please to the supplementary bundle, tab 4. We're now in the first report of my expert, Professor Meyer-Beck.
Yes.
Can I ask you, Lordship, please to turn to page 70. And can you, Lordship, please read paragraph 29 down to 31, which deals both with the initial offer from the SEP holder and the scrutiny of subsequent conduct. what, with respect, your lordship, see from these passages is that it's quite wrong to think that the German court stops at inquiring whether an offer is not obviously unfranked. That's just the start of the process. And in simple terms, as the expert puts it, the implementer will not be injuncted unless the court believes that a FRAND license is available to the implementer with which it can regulise its infringing activities. An injunction will only follow in that circumstance where the implementer has shown itself to be unwilling to enter into that license. Now, it is certainly the case, and I don't dispute this at all, that the German court deals with FRAND issues in a different way from the way in which the English court deals with it. Perhaps one of the principal differences is that issues about the party's conduct, willingness or otherwise, loom much larger in the German FRAND framework than they do in the English FRAND framework as currently interpreted.
To the question I was asking Mr. Alexander about. It's indisputable that the number of FRAND determinations by the German courts is 0. In answer to my question about whether there was even jurisdiction in Germany to determine FRAND, he submitted that, as far as he was aware, and this fits with my understanding, there is yet no decision that establishes that the German court even has jurisdiction to determine what is FRAND on a global basis.
My lord, I can't take it any further than the evidence. There is certainly no decision in the evidence which identifies that there is that jurisdiction. What the evidence does show, however, is that there is the Orange Book procedure in Germany, whereby if an implementer takes a license on the patentee's terms, the implementer...
The Section 315 application is untested. Nobody's done it.
Well, my lord, the experts in this case were agreed, and the judge
They were
found...
agreed that nobody's done it.
Indeed, but they were agreed that it was a route available to the parties by which to address this situation. And even if it were not a route available to the parties in Germany, it is a route available by virtue of our non-enforcement proposal here. Xiaomi can accept our terms today and have them varied in due course, if that is what FRAND requires, following the October trial. But it doesn't want to do so. It wants a license, but on its preferred terms. And commercially, really, that is the dispute at the heart of Xiaomi's application. Does Xiaomi get to decide what terms govern the license in the interim period?
I agree with that. It seems to me you put your finger in. This was the point I was putting to Mr. Alexander towards the end of his submissions. Because on one view, the real, as you say, the real dispute in this appeal is whose terms should govern the interim. Because actually your clients are perfectly content with an interim solution if it's on your terms.
Indeed.
And one way forward of that, I put to Mr. Alexander, and I'd be interested in your comment, is for the court to say, well, fine, given the real issue between the parties is whose terms operate in the interim, why doesn't the court just do what it thinks is a reasonable solution in the interim?
Well, can I answer that this way? Of course, on our case, there are a number of steps that need to be gone through to get to that point. First of all, Xiaomi would have to show a right under the XEIPR policy, which is predicated on it showing that we are acting in bad faith. And you've heard my submissions that it cannot show that. Your lordships would then need to be satisfied that it would serve a useful purpose to make declarations as to license terms. And we say the judge was correct to conclude that it would not. Indeed, it would be wrong in principle to do so.
Yes,
there is a further...
So your client's position is that there is only one possible interim arrangement, and it's on your terms. It's neither what Xiaomi asks for, nor is it a fair middle ground decided by the court.
Indeed, my lord, and that is Xiaomi's position as well. Because
Well,
what
I don't think so, because I understood Mr. Alexander to accept that the court could plump for a middle ground by way of an interim solution.
But certainly before the judge below, Xiaomi's position was that it was only prepared to enter into an interim license on the particular terms it had put forward. It's an important point, my lord, and it's a point I emphasised at the outset of my submissions to the judge, because prior to that hearing, Xiaomi had indeed been adopting the position that it would enter into an interim licence on such terms as the court declared. That was not its position before the judge. I didn't understand from Mr. Alexander's submissions that that is Xiaomi's position now. I don't understand him to be undertaking to your lordship to enter into an interim licence on such terms as this court declares to be appropriate, if this court is satisfied that that is the right thing to do. As I understand, the parties' positions are fully aligned.
He can clarify in his reply.
Well, so that concludes the point I wanted to make about what the German proceedings really are. Can I deal next with my Lord Justice Phillips' question about unwired planet and the nature of that jurisdiction, and whether the jurisdiction recognised in that case by the Supreme Court extends to the grant of interim declarations such as are sought in this case? And the answer to that is no. And it's not just no because that was not a point which the Supreme Court had to consider, or indeed which any court had to consider in Unwired Planet. It's a no because the reasoning of the Supreme Court in Unwired Planet in support of the jurisdiction to declare FRAND terms is all reasoning predicated upon the English court finally adjudicating upon claims to vindicate English patent and granting relief for. It is a relief following that adjudication. That reasoning just does not apply in the interim context. It is, as my Lord Justice Phillips put it, a wholly different kettle of fish in the interim context. Because the court is not, at this stage, the court was not in April when we were before Mr. Justice Leach, trying any claim at all. It was just determining an interim application. So Unwired Planet did not provide the jurisdictional basis for what the judge was being asked to do. That's why the parties focused before the judge on whether the ETSI IPR policy either should be construed or whether the French law doctrine of good faith had the effect that Panasonic was bound to grant an interim license. And the judge accepted, with respect correctly, our case that that is not the effect of the ETSI IPR. And that on the fact of this case, it was not in bad faith for us to refuse an interim license and to proceed with the foreign actions. My Lord, I see the time. I think in the course of dealing with those three introductory points, I've covered much of the ground I wanted to address in my first chapter on the overarching points. Can I just give your Lordships some references in the judgments to points on the law which we invite your Lordships to have in mind, not least because they are not challenged in this appeal. I've shown your Lordships the passages on antecedent injunctions. They are from 70 through to 76. And I invite your Lordship's attention, we're in the core bundle, tab 8, to page 122, where the judge deals with the authorities and declarations. And the judge, as I say, these passages are not challenged on appeal. The judge directed himself by reference to 4 appellate authorities. The first is Clark and Fenniscandia in the House of Lords, making the well-established point that the court does not grant declarations for hypothetical, premature or academic questions, only for live and practical ones. That, for your Lordship's note, was a case in which declarations were being sought from a Scottish court as to the enforceability of a foreign judgment in Scotland, in circumstances where the judgment creditor had said, I've got no interest in enforcing my judgment in Scotland. And the reasons put forward for seeking the declarations was that they might have some utility in foreign proceedings. And the House of Lords held that that was an impermissible purpose. There is then this court's decision in Howden and Ace. And perhaps I can just ask your Lordships to reread what the judge said about that authority at paragraph 79.
Yes.
Now, as your Lordships have seen, Howden was a case in which the declarations being contemplated were declarations as to English law questions. And this court thought it was not appropriate to grant them for the purposes of foreign proceedings when the foreign court hadn't asked for them. Of course, the declarations that Xiaomi is seeking in the present case are not declarations as to rights under English law. They are declarations as to alleged rights under a French law-governed international contract, the FCIPR policy. So if anything, this is a stronger case than Howden was. And indeed, we say this is a case which falls squarely within the ratio of this court's decision in Teva and Novartis, with which the judge deals at paragraph 80, in which this court, my Lord Justice Arnold giving the court's judgment, held that as a matter of principle, it is wrong to make declarations for the sole purpose of influencing the foreign court's decision. Perhaps can I just ask your Lordships to read paragraph 51, which records the conclusion of principle.
It's not quite the same situation, is it?
In what sense, my Lord?
Well, the English court isn't being asked to make a declaration on an issue governed by the law of Germany.
No, that's true. It's being asked to make a declaration on an issue governed, as this court sees it, by French law under the FCIPR policy. But what it certainly is not is an issue governed by English law. No party is suggesting that the FCIPR policy is governed by English law. Obviously, it's not.
But again, it's a situation in which parties have both chosen to undertake to accept the English court's jurisdiction on that issue, in determination of that issue.
I don't dispute that.
As a matter of French law.
The parties have agreed, well, each party has undertaken to the court to enter into a licence on such terms as the court declares to be FRAND.
Yes. So there's no question here of the type of imperialism that is depreciated or deprecated, because the parties themselves have said this is a matter we accept the English court can decide and we will be bound by.
Well, it all turns, my Lord, on what there is your Lordship's question. The matter that the parties have each undertaken to be bound by is what are the terms for a FRAND licence to be declared by the court in due course. The parties have not submitted to the English court the question whether Panasonic's German patents are valid and infringed. if they are being infringed, whether it is appropriate to grant injunctive relief. None of those questions has been submitted to the English court. And as the judge recognised, what Xiaomi is seeking to do through the English court is to establish a contractual defence to those German law claims on German law patents. It wants to be able to turn up in Germany and say, Panasonic is obliged to grant us a licence. And that provides us with a defence to Panasonic's claim for infringement of the German patent.
But you've agreed to grant a licence on the terms the English courts determine.
Indeed, in future,
Which
we have.
Yes, but which will apply to the present period.
Indeed, but as matters stand, that has not yet occurred. I mean, this is the point we debated at the outset, and I don't have a different answer to your Lordship's question.
But what we're talking about now is whether this is a situation that Lord Justice Arnold had in mind in Teva when he was talking about what it was wrong for the English court to do. And Lord Justice Arnold is in a much better position than I am to. But looking at his words, it doesn't seem to me that they are applicable to this situation.
My Lord, let me deal with that. The principle that is identified in the first sentence in the passage quoted is, it is wrong for an English court to make a declaration solely for the purpose of influencing a decision by a foreign court on an issue governed by the law of the foreign court. The issue with which the German court is seized is, should we grant injunctions or not? That is the issue in relation to which Xiaomi seeks declarations to influence the German court. And it seeks those declarations as to its alleged rights under French law. So we do say we fall within that principle. Then
Well, you could say the same thing. Can't you say the same thing about the ultimate license? In the ultimate license you get in the FRAND proceedings here would influence proceedings in any other jurisdiction for infringement.
My Lord, no, you can't say that about the ultimate license because each of the parties has undertaken to enter into it.
But it's still designed to give a defence to any infringement proceedings.
Indeed, but it is being granted as part and parcel of relief on claims in England for infringement of UK patents.
Yes, and so would the interim licence.
But with respect, no,
It
my
would
Lord,
be
because
the English court exercising its well recognised power to grant interlocutory remedies to hold the position pending its determination of the substantive issue.
Indeed, my Lord. And if there were a risk of us seeking injunctive relief in England ahead of the October trial, I recognise that is a way in which the English court could exercise those ancillary powers. But the only risk of an injunction in this case is in Germany. And so it follows that the only purpose of making those declarations would be to influence the courts in Germany. And that is an illegitimate purpose, applying the ratio of Teva. And one sees the rationale for that in the reasons given in Lord Justice Arnold's passage that the court has here. It's not the court's function to provide advisory opinions. The English courts have no special competence to determine such issues. If anything, it is likely that they have less competence than the local courts. It makes no difference that the English court and the foreign court are applying the same basic law. Furthermore, comity requires restraint on the part of the English courts. And your Lordship see exactly the same points in the TQ Delta case, which this court relied upon in formulating the principle in Teva. And since we have it open, can I just ask your Lordships please to read paragraph 81 and the quotations from TQ Delta that follow it.
Yes.
Well, can I turn next to my second topic, which is to deal with those of Xiaomi's grounds, which address the judge's conclusion that there was no basis for the declaration sought. And as I indicated in opening, we understand those to be grounds 1, 2, and 5. Ground 1 is the contention that because the judge asked himself at the interlocutory hearing, as the parties agreed that he should, whether Xiaomi had made out its case for relief to a high degree of assurance, it is now said that the judge applied the wrong approach. And that ground is unsustainable, we say, because it ignores the procedural context in which Xiaomi's application came before the court. It misunderstands the applicable principles. And it unfairly criticises the judge for approaching the application as Xiaomi agreed that he should. My lords, so far as concerns the procedural context, as I said when I interrupted, I hope helpfully, my friend's submissions, the matter came before the judge by an application notice issued under CPR Part 23. Xiaomi never sought directions for trial of an issue as regards the declaration sought, and no such directions were ever made. It is true that at the CMC, before Mr. Justice Mead, the judge directed Xiaomi to plead in draft its case in support of the declaration sought. And Xiaomi did plead in draft, and we pleaded back in draft. But there was not before the court at the April hearing any claim for those declarations, nor was there any direction for trial of that claim. All there was the application notice, supported by the evidence served in support and the draft pleading. In the evidence that was served in support of the application notice, Xiaomi said the application was made on the basis of CPR Part 23, Part 24, Part 25, and the inherent jurisdiction. There was no suggestion in that evidence that this was trial of an issue. Now, against that background, there were debates between the parties ahead of the hearing as to whether Xiaomi was seeking an interim declaration or a final declaration, whether the application should be confined to relief on a summary basis under CPR Part 24 and 25, and whether there should be any cross-examination, as Xiaomi had proposed for the first time in the week before the hearing was to come on. In the end, and happily for the judge, there was no need to resolve those procedural debates, because an agreed position was reached ahead of and during the course of the hearing. Your Lordship sees it recorded at paragraph 87 of the judgment, where the judge says this: both parties accepted that Xiaomi was in substance seeking final relief. They also accepted that the appropriate test which the court should apply was whether the court was satisfied to a high degree of assurance that Xiaomi was entitled to the declarations asked. And so far as concerns the cross-examination aspect, we opposed cross-examination in our skeleton at the start of the hearing on the straightforward basis that it wasn't a trial, so there shouldn't be any cross-examination. In the end, Xiaomi did not move its application for cross-examination, as the judge points out at various points in his judgment. And that was obviously very important because, in the usual way, it limited the findings that the judge was able to make. In particular, when the judge was taxed with allegations as to bad faith, allegations as to what is FRAND or not for Panasonic's portfolio. The judge was effectively being asked to resolve those issues on a final basis without any opportunity for cross-examination, and without any expert valuation evidence, such as one would ordinarily see at a FRAND trial. And the judge was alive to the limitations in the interlocutory process which the parties had brought before him. And so, unsurprisingly, we say, accepted and proceeded on the correct and indeed agreed basis that he would need a high degree of assurance before granting the relief that Xiaomi sought. And as we point out in our skeleton at paragraph 25, the high degree of assurance approach, which I have just summarised, is very well established, both in the context of injunctions and in the context of declarations. It's illustrated by the two authorities which we cite in paragraph 25 of our appeal skeleton. Well, can I just show you one of them, which is particularly instructive, because it was a case like this one, in which the issue to be dealt with at the interlocutory hearing would never be revisited at the trial. It's the Koza case. That was a case in which the lower court had granted an injunction at an interlocutory hearing on the basis that the respondent company threatened to engage in conduct, funding an arbitration that would arguably breach its undertaking to the court to use its assets only for the ordinary and proper course of business. Now, one of the points raised on appeal was that the question whether the conduct would in fact breach the undertaking would never be determined at trial, and this court held that that did not matter. The correct approach was to require a higher degree of assurance before granting the injunction, and the lower court had been satisfied of that when making the order under appeal. Lord Justice Popplewell addressed this issue in his judgment, with which Lady Justice Asplin and my Lord Justice Moylan agreed. Lordships have it in the authorities bundle.
Oh, my lord was in the minority in this case. I may be this. Certainly, the head note records that he was in the minority, but maybe not on this question.
Not on this question. As I recall the case, the dissent was on the question of abuse of process. Right. One of our arguments, I acted for the respondent in that case, was this was a second bite at the cherry, and it was therefore abusive. We came second on this issue, but Lord Justice Moylan at least saw the force of the points we were making. But that's not the point that I take the Lordships to the case for. If we can turn up tab 8, please, in the bundle, and if I can ask you Lordships to turn ahead to paragraph 75 on page 162 of the bundle. And can you Lordships please read paragraph 75 down to the end of 77. What we say this illustrates is that Xiaomi is wrong to suggest, as it does in paragraph 43 of its appeal skeleton, that the high degree of assurance requirement is designed to ensure, and I quote, "the merits of the relief sought will not be altered by further evidence or arguments presented when the matter is revisited at trial." This principle has nothing to do with whether the matter will be revisited at trial. The principle applies because the relief is being sought at an interlocutory hearing, which will in practice have final effect on the parties' rights. That's why, before the court will do that, it has proper regard to the limitations in the interlocutory process and requires a high degree of assurance as to the merits. Can I deal next, my lord, with the fact that Xiaomi agreed to the court requiring a high degree of assurance? Your lordships have Xiaomi's submissions on this below in the supplementary bundle behind tab 16, page 284. Can we go there, please?
Can I just ask that the Koza and Koza Altin case came back to the Court of Appeal later, didn't it?
It did, my lord. Yeah, yes.
Before the Chancellor.
Yes, it did. It came back before the Chancellor on an issue entirely unrelated to the matters before your lordship. It was on the arguability of a claim that was brought. The second Koza case has nothing to do with this issue.
Yes.
I was dealing, my lords, with Xiaomi's agreement on this aspect. And we pick this up on page 78 of the transcript, line 19, where Mr. Bolton says, French law with a slight detour via whether this is a trial. Right, and Mr. Bolton says this: we have been comfortable accepting the phrase high degree of assurance on the basis that we do not see that as intended to vary the ordinary civil standard of the balance of probabilities. It is a warning that in cases where the court is being asked to decide issues at an interim stage on limited evidence, the court has to be careful that there might be further evidence to come out at the final trial. Well, with respect to him, he's wrong about the at the final trial aspect, but the rest of it is accurate enough. And the high degree of assurance test is not going beyond the civil standard as to the balance of probabilities. Just asking whether the court has a high degree of assurance that that standard will be met, bearing in mind the limitations in the interlocutory process. So, with respect to Xiaomi, the whole premise for ground one, which is that the judge applied a higher test than balance of probabilities, is wrong. He didn't. If anything, as my Lord Justice Phillips observed this morning, he applied a test that was more generous than he ought to have done. In any event, it certainly wasn't less generous to Xiaomi than it should have been. My Lord, finally, on ground one, we do say this: it is very difficult to see how it assists Xiaomi in any event. The punchline of it appears to be the point in paragraph 46 of the appeal skeleton. The judge was required to determine whether, on the balance of probabilities, on the evidence before him, Xiaomi had established the facts that would entitle it to the interim license declaration sought. That's exactly what the judge considered, whether the evidence before him established the facts sufficient to make out those declarations, rightly taking account that much of the evidence was in the form of witness statements or expert reports from people who had never been cross-examined. And what the judge really appears to have done in those passages of the judgment which emphasise the need for a high degree of assurance is to emphasise that point in the context of parts of the written evidence that were not tested in cross-examination and which were important to the matters he had to resolve. With respect to the judge, that approach was entirely correct. Indeed, any other approach would have been unfair and properly a matter of complaint to this court. My Lord, I turn next to ground 2, which is the contention that the judge erred in concluding that the French law doctrine of good faith did not require Panasonic to enter into an interim license. Now, we addressed this ground at some length in our written argument, Your Lordships, at paragraphs 26 to 45. We maintain those submissions, which I'd ask Your Lordships to bear in mind against the background of the overarching points I addressed earlier in my submissions. What I want to do now is focus, if I can, on some of the bigger picture points in relation to the bad faith issue. And the first is this: it's to invite Your Lordships to keep well in mind that there was below no dispute on the applicable French law test so far as concerns the doctrine of good faith. There was also no dispute that it requires a highly fact-sensitive exercise. That exercise required the judge to take account of and evaluate all relevant matters bearing on the question of good faith. The second point is that this court will usually interfere with such a multifactorial exercise only where the lower court has erred in principle, taken into account irrelevant matters, ignored relevant matters, or reached a conclusion that is perverse. And we say the judge made no such error. The third point, third big picture point, is that Xiaomi's primary case to the judge, submission A, as the judge described it, was put squarely on the basis of subjective bad faith. The allegation that by refusing an interim license, Panasonic has adopted a strategy of seeking super-FRAND rates. That was a serious allegation for Xiaomi to advance. It is an allegation which Panasonic denied for the reasons set out in its pleaded case and evidence. And it was an allegation which Xiaomi pressed ahead with at the hearing on an inferential basis without pressing its application to cross-examine. And it was in those circumstances that the judge was not satisfied that the allegation was made out for the reasons he gave at paragraphs 96 through to 100 of the judgment, which I have already shown Your Lordships. It is no part of Xiaomi's appeal to challenge the judge's findings on subjective bad faith. Rather, ground 2 is formulated on the basis that the judge was wrong to hold that, and I quote, viewed objectively, Panasonic's refusal to offer an interim license did not frustrate its FRAND commitment. And the ground is developed in the same objective way in Xiaomi's written argument, as Your Lordships clearly see, for example, at paragraph 46.1 and 47. Now we accept, as we accepted before the judge, that the test under the French law doctrine of good faith is an objective one, but it falls to be applied against the backdrop of the judge's unchallenged finding that, as a matter of fact, Panasonic's subjective purpose in refusing to enter an interim license is not to frustrate its FRAND commitment, nor to pressure Xiaomi into super-FRAND rates, but instead to promote a negotiated FRAND license by pulling on levers which it regards as legitimate. My Lord, the fourth big picture point is that the objective formulation of the bad faith case turns in the end on assessing whether the effect of Panasonic's pursuing the foreign proceedings will be to frustrate its FRAND commitment. Xiaomi's argument is premised on showing that the German court's approach to injunctive relief in FRAND cases is one that will force it to accept super-FRAND rates and therefore will not achieve a fair balance between the interests of implementers and set holders. Now, the judge concluded that our conduct would not objectively have that effect for the reasons set out at paragraph 101 of his judgment. And we say those reasons are unimpeachable. At their heart are four fundamental points, which are either undisputed or else are incapable of serious dispute. The first is the point I began my submissions with this afternoon. Xiaomi did not suggest to the judge, and nor could it, that our pursuit of the German and UPC proceedings is in breach of our undertakings to the English court. That is the point the judge made at paragraphs 101, 1 and 2. Those passages were not challenged in Xiaomi's appeal, for which this court gave permission. And the first occasion on which there was any suggestion of breach of undertakings was in Mr. Alexander's submissions this morning. And it is not a point that is open to Xiaomi on this appeal. It is also an utterly unsustainable point, given the terms of those undertakings and the context in which they were given. Well, the second fundamental point is that in the absence of an undertaking to the court, or a contractual obligation not to pursue the foreign proceedings, it cannot be illegitimate for Panasonic to enforce its legal rights in the German and UPC courts and obtain such relief as they are prepared to grant. That is the point the judge made at paragraph 101.3 of his judgment. The third is that once the German law position is properly and fairly taken into account, and the caricature that you were offered this morning is put to one side, there can be no doubt whatsoever that the German courts and the UPC will fully take into account Panasonic's FRAND commitment when deciding whether to grant injunctive relief, applying the FRAND framework as those courts understand it, as articulated by the CJEU and by the German Supreme Court. And the consequence is that those courts will not grant Panasonic injunctive relief if Panasonic is found to be abusing its dominant position by refusing to negotiate FRAND terms, including by its refusal to enter the interim license that Xiaomi wants. And that is the point that the judge made in paragraphs 101.4 to 6 of his judgment, which I've shown you, Lordships, by reference to the German evidence, untested, as I have said, by any cross-examination, and which the judge had addressed in greater detail at paragraphs 46 to 60 of his judgment. The judge specifically addressed in this context, as you Lordships have seen, the points made by Xiaomi's expert about obviously unfriend. And the judge explained why he did not accept them in the light of the qualifications added by Panasonic's German law expert, who, as I have said, was not cross-examined on the point. My lords, while we're on paragraph 101, can I just show you a final subparagraph I don't think I showed you earlier. We can go back to the core bundle, page 139, just to round off the judge's reasons on the objective aspect. Can I ask you, Lordship, please, to read subparagraph 7?
Yes.
And this really is the fourth big picture point, and the judge appears to have regarded it as important hence his word moreover at the start. There is nothing to prevent Xiaomi from relying on the undertakings given to the English court in support of its case before the German courts, as evidence that it is a willing licensee and that we are an unwilling licensor. And there is likewise nothing to prevent Xiaomi from relying on what has come to pass in the context of this interim license application. And indeed, both of the parties are relying on those developments in support of their respective cases on willingness before the German courts. And on this point, it is entirely unsurprising that the judge observed, with respect, at the end of paragraph 101, subparagraph 7, that these were matters best left to the German court. Because whereas they are matters which bear on what the German court has to decide on willingness, they have absolutely no bearing on what the English court is going to decide at the FRAND trial. Well, I was returning to the big picture points on ground 2. Our fifth is that in assessing whether the effect of Panasonic's conduct is to frustrate its FRAND commitment, it is critical accurately to identify what the commitment entails. And the judge addressed this at paragraph 103 of his judgment, when rejecting Xiaomi's case that the FRAND commitment entails an obligation to grant an interim license. Can I ask you lordships to go there, please? We're on page 140.
Yes.
Your lordship sees the conclusion. I'm not satisfied to a high degree of assurance that Panasonic's FRAND commitment imposes an obligation to grant Xiaomi a FRAND license now. Subparagraph 1 accepts that the French law principle of good faith might modify a party's substantive rights and obligations. And so the judge says it would in theory be possible to imply an obligation. The judge then dealt with and rejected my submission that the wording of clause 6.1 precluded references to interim licenses subject to true-up provisions on the basis that they would not be irrevocable. The judge was not persuaded by that point, and it's not the point we pursue on this appeal. And this, in subparagraph 3, I find it impossible to imply from the express words of clause 6.1 an obligation to grant an interim license. The only express obligation imposed by clause 6.1 is to give an undertaking to the Director General of ETSI that the SEP holder is prepared to grant irrevocable licenses. This language is intended to demonstrate a present intention to grant future rights. FRAND commitment is therefore a binding commitment to grant future rights if the SEP holder's offer is accepted. Subparagraph 4. Mr. Scott submitted that the only further obligation which the undertaking to ETSI imposes on a SEP holder is an obligation to make a FRAND offer which is capable of acceptance. I accept that submission. See Nokia and Oppo at paragraph 258. Moreover, there was no authority to which I was taken that a SEP holder is required to make an offer in a particular form to cover particular license periods, or indeed to make more than one offer to cover different periods. The only obligation is to make an irrevocable offer on FRAND's terms. Now, our position is that we have already made a series of FRAND offers to Xiaomi in the past. We have also undertaken to the English court to make a FRAND offer in the terms which the English court declares to be FRAND at the October trial. We have done what we are required to do under the ETSI IPR policy commitment in clause 6.1. The pursuit of the foreign proceedings will not frustrate performance of that commitment in any way. working through to the next subparagraph, I need to show you, Lordships. Subparagraph 6. I ask you, Lordships, to read that, please.
Yes.
My lord, the analysis of objective bad faith might, and I stress it might, have been otherwise if the approach applied by the German courts and UPC courts did not, in the judge's words, achieve a fair balance between the interests of implementers and owners of SEPs. But the judge was not prepared to accept that that was the case in Germany. And the judge was plainly correct in that, given the foreign law evidence before him. Indeed, we do say this: it would obviously be a strong thing for the English court to say that a foreign court will not fairly balance the interests of the parties before it. That is a finding that the foreign court will not deliver substantive justice in respect to the parties' dispute. Now, of course, the English court can make such findings when it needs to, but comity demands that the English court do so only when presented with cogent evidence supporting the finding. Here there was no cogent evidence, indeed there was none at all, that the German courts are incapable of justly determining cases with which they are seized, and in doing so taking account of FRAND matters as part of the German FRAND framework drawn from EU competition law. There's just no evidence at all that the German courts would not do that in a just and balanced way. The judge was also correct, we say, to have regard to the practicalities when he assessed and rejected Xiaomi's case that the FRAND commitment entails an implied requirement to grant an interim license. One aspect of this is the point the judge made at subparagraph 7. Can I ask you, Lordships, please to read subparagraph 7, noting that Xiaomi had not formulated the precise implied term which it sought, and nor was the judge able to do so. He said it was impossible.
Yes.
My lord, finally on this, the judge dealt at subparagraph 8 with the spirit of the ETSI IPR policy, which the parties agreed failed to be taken into account under the French law doctrine of good faith. But the judge was not satisfied that this provided any basis for Xiaomi's case on bad faith either. Now, my lord, so far as concerns the particular errors that Xiaomi asserted in its written argument under this heading, it will not be possible in the time left available to me to deal with them point by point. We have dealt with them point by point in our written argument. That's at paragraphs 34 to 45. As I understood my learned friend's submissions this morning, his central point on ground 2 is the suggestion that the judge did not understand that the ETSI IPR policy imposes behavioural obligations on the parties. With respect, that is fundamentally inconsistent with the whole debate before the judge in relation to ground 2, which is whether or not Panasonic was conducting itself ahead of the FRAND trial in a way that was either subjectively in bad faith or objectively in bad faith. And the judge concluded, with respect, rightly, Panasonic is not acting in bad faith, either objectively or subjectively. In other words, can I turn next to ground 5? Ground 5 seeks to challenge two subparagraphs of the judgment. And it does so, and I quote now from the ground, to the extent that the learned judge made a finding that Panasonic's non-enforcement proposal was arguably sufficient to discharge Panasonic's obligation to offer Xiaomi a license at this stage. So it's a sort of conditional ground of appeal directed at two subparagraphs. And the short answer to this ground is that it mischaracterises what the judge was doing in this part of his judgment. Can we go please to page 143?
Yes.
And we pick it up at paragraph 105.
Yes.
Your Lordship sees that the judge is dealing here with the second question identified for him. Are the terms of the interim licence proposed by Xiaomi appropriate, or is Panasonic's non-enforcement proposal appropriate and sufficient to discharge its FRAND commitment? And as the judge makes clear in the first sentence of 105, this question did not arise in the light of his conclusion on the prior question, namely his conclusion that that Xiaomi had failed to establish that Panasonic was obliged to offer an interim arrangement in the first place. As the judge went on to say in the second sentence, he made brief observations, his words, about it, because, in my judgment, the formulation of the declarations which Xiaomi asks the court to make illustrate the difficulty which the court will have if the answer to question 1 had been positive. The points made by the judge do well illustrate the difficulty, the thrust of them being that it was impossible in the context of the interlocutory application before him to resolve the question whether Xiaomi's proposal or Panasonic's proposal was FRAND or unFRAND or somewhere between the two. And that is a point he highlighted at subparagraph 7 of paragraph 103 of his judgment, which I've shown you lordships already. Now, Xiaomi criticises the judge for this, making 2 points, neither of which, with respect, is sustainable. The first is the suggestion at paragraph 79 of Xiaomi's appeal skeleton, that our proposal was, and I quote, not a bona fide offer intended to be capable of acceptance, but rather an artifice designed to be unacceptably burdensome. And as we point out at paragraph 47 of our appeal skeleton, that appears to be an allegation of bad faith, for which there is no proper evidence, not least given Xiaomi's choice not to seek to cross-examine Panasonic's evidence below as to the nature of the proposal it had made and the rationale for it. I didn't understand, in fairness to him, a learned friend as part of his oral submissions, to repeat that new allegation of bad faith which emerged in the appeal skeleton. The second criticism is the suggestion, which really underlies all of ground 5, that the court is in a position at this stage to determine whether the terms proposed by either side are FRAND. But that is impossible, as the judge rightly recognised. We have given examples of the difficulties at paragraph 48 of our appeal skeleton. But the essential point is that the judge was in no position, and with respect nor is this court, to determine what terms would be FRAND for a licence Panasonic's portfolio, whether as to the royalty rate, the past term of the licence, the interest payable in respect of past use, or otherwise. They are all matters for the FRAND file. My lords, can I turn now to my final topic, which is those of the grounds of appeal dealing with utility and comity, so far as concerns the declarations. I start with ground 3, the suggestion that the judge erred in law or failed to take account of relevant matters in concluding that the declaration sought would serve no legitimate, useful purpose. But also, so far as the concerns the contention that the judge erred in law, Xiaomi's appeal skeleton identified no such error when addressing ground 3. The Lordship has the written submissions at 62 to 68, and I didn't detect in my learned friend's oral submissions this morning any suggestion or justification for the contention that the judge erred in law so far as concerns useful purpose. With respect, that is unsurprising because the principles on useful purpose are well established by appellate authority, which the judge identified in his judgment in passages which Xiaomi does not challenge. As I understand it, the way the case is put is to say that the judge erred in his approach, failed to take account of relevant matters, or had regard to irrelevant matters. And I'll deal with that. But that is not a case that the judge erred in law or erred in principle. The judge identified the correct principle. Insofar as there were any sustainable appeal here, it could only be on the basis that the judge erred in approach. And he didn't. The judge's approach was, with respect, entirely right. He took account of all relevant matters and didn't take into account any irrelevant ones. Xiaomi's main argument on this, and your Lordship sees this at paragraphs 63 and 64 of its appeal skeleton. The main argument is that the primary purpose, Xiaomi says, of the declarations was to influence Panasonic to enter an interim license. And it is suggested that the judge did not address this useful purpose at all. With respect, that is wrong. It was clear to the judge from the evidence before him that Panasonic would not enter an interim license, even if the declarations sought were made. Can I give your Lordship 3 references? We needn't turn them up. The first is Panasonic's draft reply and defence to counterclaim at paragraph 33J, subparagraph D, which Panasonic specifically pleads that there can be no utility because, even if the declarations were granted, it would not enter into an interim licence. That's tab 17 in the core bundle, page 265. The second is Mr. Jelf's first witness statement, paragraphs 29 and 30. That's the supplemental bundle, tab 2, page 29. And the third is Mr. Jelf's second witness statement at paragraph 12, supplemental bundle, tab 7, page 12. And in the last of those documents, Mr. Jelf makes the point on instructions from Panasonic. That is a stance Panasonic is taking, well aware of Xiaomi's arguments as to what impact it is said to have on willingness. Panasonic does not accept those arguments and is happy to take its chances on them in the German courts. Now, the judge was asked to read this material, and evidently he did so. For example, the pleading is quoted in his judgment at paragraph 19. Your Lordships will have seen the extensive references to Mr. Jelf's evidence in his judgment. The fact that Panasonic would not be entering an interim licence, irrespective of the declaration sought, that was a point that we emphasised to the judge in support of our argument on useful purpose, which the judge accepted. And your Lordships see that very clearly from paragraphs 110 and 111 of the judgment. Can we go there, please? Can I ask your Lordships please to read 110 and 111 down to where the first subparagraph starts? We don't need to go beyond that at the moment.
beginning to run out of time.
I'm very nearly done. I'm hoping to be done by about 20 past, which I think will be considerably less than the time Mr. Alexander had, but still enough for him to reply. I'll obviously go as quickly as I can. So what we take from those passages is that I made to the judge the point in the context of useful purpose, that we would not be entering into the license, and he accepted the point. And so we say ground 3 must fail, because influencing Panasonic cannot have been the primary purpose, or indeed any purpose of the declaration sought, in circumstances where Panasonic has made clear that it would not be influenced. And the judge rightly recognised that and relied on it, as your lordship sees from his judgment. And in the balance of paragraph 111, what the judge is doing is explaining why the declarations have no utility in the context of the English proceedings, and why therefore their only utility could be in the context of the German proceedings, which would be illegitimate. And with respect, the judge was entirely correct in that conclusion. There was no error of approach. My lord, can I deal finally on ground 3 with Mr. Alexander's suggestion this morning that things may have moved on since the April hearing, such that it is possible that Panasonic's position has changed as regards entry into an interim license? It has not. We made very clear in our appeal skeleton on Monday of this week that our position remains the same. And can I make that point clear again to your lordship? Our position remains as it was before the judge.
Yes, but I presume you will not dispute that parties' intentions can change, just as your clients have changed their case on the amount that represents FRAND.
My lord, I can't dispute that parties' intentions can change.
Yeah.
But your lordship will read the evidence and see the way it's put. It would be surprising in the light of that evidence if Panasonic's position was to change. But I cannot say it is not, that it is impossible. My lords, if you're with us on ground 3, in a sense that is a complete and short answer to this appeal, and indeed an answer that would obviate the need to dip the court's toes into some difficult waters as regards the impact of the ETSI IPR policy. It would be enough to find that the declarations have no utility, and so it would be wrong in principle to grant them. Well, can I deal finally, briefly, with the points on comity, which are the subject of ground 4 of the appeal? So far as concerns the law, the judge correctly directed himself by reference to Deutsche Bank, which, as I said, is the, or at least a leading authority in the anti-suit context, where considerations of comity loom large. What Xiaomi seeks to do in its arguments is effectively to invite the court to treat this case as if it were one involving an English exclusive jurisdiction clause, in the context of which comity considerations are less weighty. The short answer to that is that the reciprocal undertakings are not an English exclusive jurisdiction clause. They lack all the defining features of an English exclusive jurisdiction clause. They are not an agreement between the parties, and they do not contain an obligation not to pursue proceedings elsewhere. On the contrary,
You say they're not an agreement between the parties. I don't understand that. They're embodied in a court order, but why are they not equally an agreement between the parties?
so of course, in principle, properly construed, court undertakings might well also be an agreement between the parties. But these were not. We made very clear when we gave them, these were simply undertakings to the court. And that is a point the judge recorded in his judgment
I
at paragraph
appreciate
101.
the limits. There's a difference between the question of the limits of the undertakings given and the question of what your clients made clear as to their position on those limits. But is there any specific evidence that you rely upon to show that the undertakings don't take effect as an agreement between the parties? Given that they are reciprocal.
My lord, I hear fluttering behind to see if there is evidence on that point. I suspect it will be
was it a
from...
consent order? If it's a consent order, then it's definitely an agreement between the parties.
My lord, I'm not sure that follows either.
Well, there's quite a lot of jurisprudence on that. So
Well, indeed, and my recollection
these
is
undertakings were given by the consent because they were reciprocal.
indeed, I don't dispute that the undertakings were given consensually. The issue is, properly construed, do they amount to a promise by Panasonic to Xiaomi, as distinct from a promise solely to the court? Your Lordship has the judge's answer on that. Paragraph 101, subparagraph 1. Panasonic gave those undertakings to the court, not to Xiaomi. And as I understand it, that position was made clear in the context of the hearing before.
But it certainly is the case that undertakings are given to the court and not to the other party. An undertaking to the other party would be useless in terms of enforceability. But that doesn't mean that they don't represent an agreement or weren't made by agreement between the parties.
Well, your Lordships have my point, that in order to conclude that they are an agreement, your Lordships would need to be satisfied that objectively Panasonic was evincing an intention to Xiaomi to enter into an agreement with it.
Do we have the order?
I'm not sure we do have the order in the bundle. I think it's quoted from instead in the judgment. But, my lords, in conscious of the time, whatever the answer were, assume against me that there was an agreement on this. What it certainly is an agreement whereby Panasonic promises not to bring proceedings in Germany on the UPC. That is an impossible construction of any such agreement. When Panasonic gave the undertakings, making clear to the court that it would not stay its hand in Germany. And that alone makes it impossible to treat them as an English exclusive jurisdiction clause, or to apply any analogy to English exclusive jurisdiction clause cases. My lords, we've dealt with the comity points at some further length in our written argument. Obviously, we rely on those points as well, but given the time, I need to sit down unless I can assist you lordships further.
No, but I think it would be helpful for us to have a copy of Mr. Justice Meade's order in any event, regardless of what the right answer on this question. So if we could be provided with a copy of that order, that would be helpful.
Certainly, my lord.
Stephen. Thank you very much. Yes, Mr. Alexander.
My lord, it's been a long day, so can I just make a few very brief points, perhaps using the judge's judgment and the points made on it as a roadmap, and take it up at paragraph 101 of the judge's judgment, on which points were made by my learned friend. That's page 137 in the appeal bundle.
Yes.
First, in relation to the Panasonic the undertakings, our submission is that these undertakings are intended to give effect to the ETSI obligation on both sides. And it is in those circumstances somewhat academic to have a debate about whether or not we say that it's a breach of the undertakings or breach of the ETSI duty. We frame our case on the basis of the breach of the ETSI duty, but in the context of an ETSI duty which is sought to be fulfilled by mutual undertakings to treat this court as the arbiter of FRAND. And it is because of that and the procedural consequences of that that we say it is bad faith not to grant a license that ensures that that process will take place unimpeded. Second point on that paragraph, in relation to supra-FRAND, our submission on that is that the judge did err as a matter of principle, a matter of law, approach, doesn't matter how you put it, because the proposition that he was applying was to say that it necessarily had to result, or he thought that we had to establish that it was necessary that what they were doing would definitely result in supra-FRAND terms, or that there was a significant risk that they will do so. The whole point of this is that it is clear that there is a risk that that would happen, because that is the very purpose of the exercise. It's perfectly obvious that that's the purpose of the exercise, because otherwise, why embark on it at all? There's no suggestion that Panasonic is seeking terms that are less favourable than the terms that Mr. Justice Mead would settle, or seeking to accelerate the terms that Mr. Justice Mead would settle. It is only directed to providing terms that are different terms. And as regards the next point on the statistics, because my learned friend made a point that said, well, there isn't adequate evidence on this, the statistics are that German courts will grant injunctions in these circumstances, and that they haven't not granted injunctions. My learned friend referred to the roadmap under FRAND, but it's his case that notwithstanding our undertakings, notwithstanding our approach, we still haven't fulfilled the requirements of German law. That's why he's making his applications to the German court. So with all due respect to him, he is not saying that we have fulfilled the requirements of being a willing licensee, notwithstanding everything that we have undertaken. The final point on this paragraph is that it was said that the judge thought that the approach was not so very different from the approach which an English court might take in infringement proceedings. But on that point, the judge was, with respect, quite wrong. The whole approach that the German court takes to deciding whether it should grant an injunction is one which does not make an evaluation of what is in fact FRAND. Indeed, one of the objections, indeed the heart of the objection to the conduct in question is exactly that the German court proceedings are invoked because they don't. They're not directed to obtaining a FRAND result. They're only directed to putting pressure on parties to enter into agreements which are not obviously not FRAND, or not off the spectrum, if I may put it like that, of things that are FRAND. So the next set of points were made on, which I can pick up on paragraph 103 of the judge's judgment, where the points were made on the ETSI scheme and what should or should not be implied into the ETSI scheme. And here, I don't really detect an answer to the point that I made, that as this court has held in the Optus and Apple case, the point of the ETSI scheme is that a implementer is entitled to a license on demand. Now, the judge said in subparagraph 3 on paragraph 141 that this language is intended to demonstrate a present intention to grant future rights. And in some senses, it may be so that it may not be possible to determine what the precise evaluation of those rights are now. But the ETSI obligation, in order for it to be an effective obligation, particularly in the context of a business, which is businesses that are continuous, is that a implementer should be able to have a license in respect of acts that it is doing tomorrow, or just as much as in respect of acts which it did do last week and acts which it may do in February or whenever after the license has been settled. That's clear law of this court upholding Mr. Justice Mead, and the approach taken by the judge with respect simply didn't do justice to that. And what one might say is that this is a point where the procedural matters and the substantive matters intersect, because if there is a right to a license now, then one might say that anything that undermines the right to a license now is a procedural impediment on the determination of terms in the future with respect to the license now. My learned friend didn't address at all, and I really don't think he could, this point about the point I made about the continuous license, nor did he address in any way the consequences of my learned friend being correct and being able to interrupt a license, which is a continuous license, on the FRAND proceedings. It is really unanswerable that if that happens, that were to be the case, that there would be effectively a significant claim by way of a kind of counterclaim for a reduction in the value of the license on the basis of that period of interruption. Now, one thing that really isn't contemplated by the ETSI scheme is to have licenses that are granted in circumstances where they provide for an interruption of business when even this court has said previously in Apple and Optus and in other cases that the point of the ETSI scheme is to provide for essentially potential to take unlimited licenses to enable business to continue. Indeed, that is a premise of the ETSI scheme. The whole point of these standards essential patents is because they're essential and no one has a choice as to whether they should use them if they wish to connect to the relevant telecommunications networks. There has to be a provision for a license now on FRAND terms. And those are points that really, my learned friend's arguments simply are not capable of dealing with. The next point I can perhaps pick up briefly on paragraph 105, where he was seeking to support the judge's judgment. The point here is that if one is settling an interim license with terms that are adjustable, one is not doing anything that is finally irrevocable. And that is why a court, as soon as it's doing something that can be fixed retrospectively, doesn't need to look at the question of whether those terms precisely are the terms that would be settled in respect of that period. What it needs to look at is the question of whether they are reasonable given the fact that they can be retrospectively adjusted. The final set of points, if I can briefly make them on paragraph 111, so page 148 of the judgment, on useful purpose. In all respectable submission, the argument just doesn't engage with it with useful purpose. The primary useful purpose for which these proceedings are commenced is so that we can get a license for the period. One might say, in the context of a manufacturing business, what greater useful purpose could there be than getting a license to do acts that its counterparty has undertaken to give, and to do so now? Now, if my learned friend says, well, we're not going to offer you a license, even if the terms are settled, that's a matter, in a sense, for my learned friends. The position may change, and it may change because my learned friend may think a little bit, perhaps overnight or when my Lord's judgment come down in due course, as to what the implications would be of the course, pursuing course that it is currently pursued. So, in all respectful submission, those are the key points that need to be borne in mind. As regards higher degree of assurance, insofar as that is the right approach, and we respectfully suggest that it isn't because of the adjustability aspects, there are certain things upon which your lordships can have a high degree of assurance. First, that Panasonic was prepared to have a FRAND valuation and indeed payment on the basis that it would be paid nothing at all until that happened. That was its position in April. And that is in fact not surprising, because that is in some senses the standard model in these industries, and that people don't get paid until the license is ultimately settled. Although, as I've said, there are other approaches in the context of copyright licensing and so forth where people do interim deals. So what is being proposed here, and to answer my Lord Justice Arnold's point about what might be called a middle ground, our proposal is already in a middle ground. It's not as though there is a kind of further middle ground. The Overton window has moved from X to a different point. The other end of the Overton window, on Panasonic's own approach earlier this year, is zero. It's not some other sum, it's actually zero. And given that, we respectfully submit that the terms that we have proposed, and for the reasons that are developed in the evidence to which I've referred, and we've referred in our skeleton argument, are really very much more than generous.
Well, I understand that point, but what's your response to the question as to what your client's position is if the court's conclusion is that a willing licensor would offer an interim license, but on terms that are midway between your last offer and their last offer?
Right. So we accept that the court can set terms, and we respectfully submit that what should not happen is a midway position, and the reason for not being the midway position are points that I've made. But we don't.
I don't mean a precise.
I understand. That's somewhere in between. Yes, I don't, or indeed somewhere less, because we respectfully submit, and that's the gravamen of my earlier submission, is that the scale goes from 0 to x. It's not a scale that goes from, as it were, w to x. I can use the numbers, but that would obviously depend on the terms, because if Panasonic has to sign and agree that the German proceedings come to an end, that's a whole part of a package of terms. And so in our respectful submission, what we can't have is a situation where this court makes a license, leaving Panasonic free to say, oh, well, the German court can completely ignore that. It doesn't matter what the English court says, we're not signing anyway. But in principle, the answer to my Lord's question is yes.
I don't understand that submission, because the whole point of your client's application, as you make clear, is that it's directed to persuading Panasonic to do the right thing.
Yes.
Now, if they're never going to do the right thing, no matter what the price, then the exercise is pointless.
Oh, indeed. And so we assume that they're going to do the right thing. And part of doing the right thing.
And if the price is a bit more than what you're currently offering, that might be thought to be more likely to persuade them to do the right thing than if it's exactly what you're offering.
I understand where my Lord is coming from, which is might be described as a market approach, not strictly juridical approach, and no criticism for that. The point is a slightly different one, though, which is that if one is doing an interim license, it has part of a package. It doesn't mean that one can then continue everything in those circumstances. Indeed, there would be a good reason not to do that. Put another way, if they don't sign up to terms that bring matters to a halt, at least pending the judgment of Mr. Justice Mead, there's no reason in principle why we should be paying, since we won't be getting anything in relation to a freedom from risk and a freedom to operate. So in terms of useful purpose, we respectfully submit that the judge really didn't grapple with the real issues. Indeed, the points that my lords see in paragraph 111, in particular paragraphs 1 to 3, but additional points further on, actually put the matter in our respectful submission the wrong way round. It's true that there may be no need to clarify the parties' respective rights and obligations because undertakings have been given. But the real point is that it is precisely because of that there is a useful purpose in ensuring that the position is preserved pending that. And it's simply not the case that the only real purpose in granting the declarations is to influence the outcome of the German proceedings. The real purpose of granting these declarations is to ensure freedom to operate under a license to which we are entitled as of today in a way that will enable the court in due course to make any adjustments that are appropriate when it comes to that point. Now, in my respectful submission, in the context of the developed FRAND jurisdiction, and bearing in mind the approach that the Supreme Court took, that is not it's not really an extra to that jurisdiction. What it is ensuring that that jurisdiction, which is regarded as valuable, is implemented in a way that is consonant with the ETSI scheme. Unless I can assist my lords further, those are our submissions.
Yes, well, Mr. Alexander, Mr. Scott, thank you and your respective teams very much for your submissions. We are reserving our judgments. They will be provided to you in draft for the usual limited purposes, and given the size of the group involved, it's very important that everybody who's part of it is aware of the limited purposes for which the draft judgments are provided. and we would expect that once you've received the judgments in draft, you will be able to agree a draft order, but if you can't, we'll deal with any outstanding matters on paper. So, thank you all very much.